On this episode of Newt's World, on Tuesday I testified in front of the House Judiciary Committee for their hearing on judicial overreach and constitutional limits on the federal courts. And I wanted to talk about the committee hearing and Congressman Darrell Iss's proposed bill, the No Rogue Rulings Act, which would limit the power of district judges to impose nationwide injunctions, like the one from Judge James Boasberg that barred the Trump administration from using the Alien Enemies Act to deport Venezuelan illegal immigrants. I'm really pleased to welcome my guest, who is also with us and is a member of the Judicial Committee, Congressman Russell Fry, representing South Carolina's 7th Congressional District. Russell, welcome and thank you for joining me on Newt's World.
Mr. Speaker, thanks for having me. It's an honor to be here, sir.
I'm really curious. We spent 5.5 hours in that hearing. What was your general reaction?
Well, two reactions. One, I thought the testimony that you and the other witnesses gave was really compelling on both the history of the courts and why we're seeing this emergence of nationwide injunction that has really grown since President Trump. And then, of course, the other big thing that stands out to me is the total inability of the Democrats to even acknowledge the subject matter for which we were there. They're talking about Elon Musk. They're talking about President Trump. They're talking about everything else under the sun, but the actual subject. And I think that seems to be kind of their playbook right now, is to not deal with the subject in front of you.
They really couldn't deal directly with the issue. As you know, there was a recent Harvard Law Review article which said that there's been a sharp rise in the number of nationwide injunctions in the first Trump administration as compared to either George W. Bush, Obama, or Biden. These last 6 weeks have set an all-time record for district judges thinking they were an alternative president. The 2024 Harvard Law Review publication found that there were 6 injunctions levied under former President Bush, 12 under former President Obama, 64 in Trump's first term, and 14 during former President Biden's first 3 years in office. In fact, of the 64 nationwide injunctions against Trump's policy, only 5 were issued by judges appointed by a Republican, leaving 92% of injunctions issued by a judge appointed by a Democrat. So, a district judge is in a district, and yet they're presuming that they can now issue an injunction across the entire country. And this has become what I described yesterday as the potential to be a judicial coup d'etat, where they're literally usurping the president's role. As of April 1st this year, there are 162 court cases against the Trump administration that involve 70 different executive orders. What's your take about what's going on?
It's a total bastardization of the federal rules of civil procedure. We are ignoring class actions, right? There is a way in which to certify if a lawyer wants to do that. Judges are superseding that. It is bad for the Supreme Court, which is the Supreme Court of all courts, that you're taking their authority and instead of having 9 justices have a nationwide rule in a court opinion that they would issue, you have 1 judge in a federal district court that is now superseding that, absent some sort of successful appeal. It is a complete violation of our separation of powers. And I think you hit on this. You have 3 co-equal branches of government. But under this rubric, you have a bunch of black robe oligarchs who are superseding the will of the American people vis-a-vis their election of Donald Trump as president. 2, and probably really interesting, is since the 1960s, the dramatic rise, particularly under President Trump, of nationwide injunctions, that you have not seen this legal phenomenon until the 60s. But even when you did, as you highlighted just now, you've seen 8 to 10 per president. You have 2/3 of all nationwide injunctions being levied under 1 president in the modern era. That's alarming. And so what we have here is an absolute case of forum and venue shopping, where you pick the lawyer who's favorable to your case, you identify the district court where you think you could have a successful case, you find your plaintiff in that district, and then you sue the president and try to stop his agenda. This is complete lawfare. The Democrats have been doing it for a very long time, but they have absolutely ramped up their efforts under the second Trump administration once again.
I was very struck that the Democrats' counter-argument is that there are all of these nationwide injunctions because Trump is overreaching his power. In fact, Representative Jamie Raskin, who you know is the ranking Democrat on the committee, posted on X, quote, "If Trump and Musk have suffered an unprecedented number of judicial injunctions, it is because they have committed an unprecedented number of illegal actions. We don't have rogue district judges. We have a rogue president violating the Constitution and breaking the law every day. I mean, what is your reaction to Raskin's argument?
To respond to Mr. Raskin, the American people elected Donald Trump to do exactly what he said that he was going to do. He is doing exactly what he said that he was going to do. He is going about the will of the people. And you have federal district court judges who are creating law from the bench rather than ruling on cases and controversies before them. That is what the Constitution requires, is that there must be an actual case in front of you. And so that if Speaker Gingrich was in front of, say, Judge Fry's court, I can only rule on Speaker Gingrich's case and not similarly situated plaintiffs all across the country. We absolutely see this, and the numbers don't lie. I mean, when you have 2/3 of all nationwide injunctions coming under one president in the modern era, it's remarkably horrendous legislating from the bench that you've seen when you were Speaker, but we also see it even more now under President Trump.
These lawyers are basically just appointed lawyers, and they're arrogating to themselves that they're an alternative president, and in fact, they're superior to the president. I think there are 667 district court judges. Imagine every single one of them decided they would take a piece of the federal government and they would be dominant and the president had to obey them. I mean, I don't think you can have 600 alternative presidents.
No, and even to get there, Speaker, these judges, certainly I've talked about Rule 23 as it pertains to class actions earlier, but Rule 65, where if you're going to issue an injunction, you're also supposed to secure a bond, which is presumably to help relieve the aggrieved party if the efforts of an injunction are not successful. These judges are not even following their own guidance and their own rules when they're issuing these injunctions. And you're exactly right. The nation and the Constitution does not contemplate 660 executives of the federal government. It contemplates one president of the United States. And something that I think was brought out a little bit too, but I want to highlight is the judges have always been, if you look at prior opinions, they've always been very hesitant to engage in issues of national security. And the reason why they do that, if you read these opinions, is that they're not in the position of understanding or seeing sensitive information, classified information. They recognize aptly that they are not the commander-in-chief, and so they're always hesitant to engage in cases where the president is exercising his commander-in-chief authority, except with President Trump, which you've seen with Judge Boasberg and these Venezuelan flights.
Not only did he say they could not deport Venezuelan criminals, but he then said, by the way, turn around the airplane and bring them back. It was an act of such, I thought, egregious overkill on his part. I'm amazed that he hasn't already been in some way sanctioned. But, Speaker Johnson suggested during a press conference that Congress could eliminate an entire district court or eliminate funding for certain courts. Let me quote him. He said, "We do have authority over the federal courts. We can eliminate an entire district court. We have power of funding over the courts and all these other things. But desperate times call for desperate measures, and Congress is going to act." What's your response to that analysis?
Well, I think we've seen this before in history, right, where Thomas Jefferson comes in and removes and creates new courts because John Adams tried to stack the courts. And so we absolutely do. This is where we have three co-equal branches of government, each operate as a check. One of the checks that we have is the power of the purse. The other is the law in the jurisdiction in which we could extend to federal district courts, maybe strengthening the bond requirement or enforcing that. And of course, the courts can police themselves. The Chief Justice is not without tools in his toolbox to rein in the judiciary. He has not done that. He rather, I think the statement that he released talked about the appellate process and that if you don't like the opinion, then you could go the traditional appeals route. Certainly that's the case. No one disputes that. But the Chief Justice also has the ability to go in and supersede his district court judges and rein them in on what kinds of cases that they can take, the mechanisms and the procedure and the process in which they're going to undertake. These are things that are at his disposal, but he has not done that.
I started my testimony at the Judiciary Committee by citing 12 names: Richard Bassett, Egbert Benson, Benjamin Bourne, William Griffith, Samuel Hitchcock, Philip Barton Kay, Jeremiah Smith, George Keith Taylor, Oliver Wolcott Jr., Williams McClung, Charles McGill, and Williams Tillman. And I did that because these were actual sitting judges. A very sophisticated lawyer had said to me, well, Jefferson may have abolished those courts, but they must have been empty because of the lifetime appointment rule. But the Jeffersonians came back and said, no, you only have a lifetime appointment if there's a court. So we're not going to try to impeach you. That's too complicated, too difficult. We're just going to eliminate the court. And therefore, by definition, you don't have any place to go to work. And it turns out every single one of them went on to find a different job because, in fact, they quit being paid. I mean, it's an amazing act.
It was a remarkable time in history. And I think it just highlights, too, the dysfunction that the other side raises right now, that this is not an attack necessarily on the judiciary. This is an attack on the abuse and the steps that they're taking that are much broader than they've ever taken before. History shows us the way, and there are a lot of things that the Congress has at their disposal to rein these courts in. Likewise, the judiciary can rein itself in as well, absent congressional bills or legislation and absent congressional action. They can do this themselves.
7 years ago, Supreme Court Justice Clarence Thomas warned, quote, I am skeptical the district courts have the authority to enter universal injunctions. These injunctions did not emerge until a century and a half after the founding, and they appear to be inconsistent with long-standing limits on equitable relief and the power of Article III courts. If their popularity continues, this court must address their legality. Is he right?
I think absolutely. And I think Elena Kagan, a liberal on the court, has been very critical of nationwide injunctions. And so I think the justices recognize the problem that we have. I think the American people see it on full display every single day when President Trump is impeded and his agenda is impeded by these district court level judges where plaintiffs are forum shopping. So everybody sees what is going on except the Democrats. And quite frankly, I think they see it too. They just don't want to talk about it.
I hope that the Chief Justice will, in fact, take steps. But if they don't, Congressman Issa introduced the No Rogue Rulings Act, which seeks to limit the power of district courts to issue nationwide injunctions. Do you think it's important to pass this?
I do. And I think in any Congress, really, as you've talked about and we've talked about today, with the increasing amount of nationwide injunctions, there's got to be some curtailment of judicial authority when it comes to issuing these. That if you're going to do them, that it might be a 3-judge panel instead of a single district court judge. That if you're going to do them, that you would strengthen the bond requirements so that you actually have to put up a bond to secure the injunction. These are all common sense things. Regulating the Administrative Procedures Act, that is a key component of what Democrats have been doing against the president as well. So reining these abuses in and streamlining the process, I think, makes for a healthier court. It also restores confidence that the court is being truly independent and an arbiter of justice and facts and the law, and not a political tool of the Democrats to achieve a result that they could not achieve through an election.
It's very interesting because in addition to what Congressman Issa is doing in the House, Senate Judiciary Committee Chairman Chuck Grassley has introduced the Judicial Relief Clarification Act, which would also limit judicial rulings to the parties involved and make injunctions against the government immediately appealable. Do you see these two bills as being comparable?
I do. I mean, there's some minor differences, but I think those are reconcilable between the two chambers. The big thing is, I think, as you talked about the appellate process, which is huge, that even if an injunction is wrong, good luck getting in front of an appellate court. That if you get a temporary restraining order, that's 14 days, it rolls into an injunction, and then you're at that particular point, you're allowed to get an appeal. But it doesn't happen overnight. So fast tracking that is huge. And so it seems to me that both chambers, while the bills are a little bit different, they have the same mindset, which is we have to rein in these out-of-control district court judges.
If you already have 162 court cases against the Trump administration, how could the Supreme Court ever hear all the appeals?
They don't have the bandwidth, right? They don't have the bandwidth in which to do that. So some things, even the most egregious abuses of judicial power, might be overlooked because there are other things that you have to work on. You remember this as Speaker. There's a lot of good policies and proposals that people put into bills, but there's only so much bandwidth that a Congress can take at any one time. The same thing goes with the courts.
In that context, how concerned are you that if we don't fix this, that in fact we have an enormous transfer of power to the courts and away from the elected officials?
It's remarkably alarming that we need to restore the balance of power between the three branches of government. There is no point, and the president might as well pack his bags and go home, and the Congress too, if it's just going to be judges that are making the rules for all of us to live under. So we've got to rein this in. But Congress has an obligation to do that. We're doing that both in the House and Senator Grassley in the Senate. And the courts equally have an obligation to rein in these practices. The justices understand what's going on. You've had criticisms of nationwide injunctions from judges on the right and the left. People see it for what it is. And so the courts absolutely should engage in this space too and police themselves. And it's probably the quicker way if the courts do this on their own without us in the Congress having to go legislate what they should be doing.
So if the Chief Justice wanted to preempt all of this legislation, how does the system work at that level?
Well, I think the Chief Justice, as the chief administrative officer for the judiciary, can issue rules and rulings and edicts, if you will, on how these things transpire. That if a judge is going to issue a nationwide injunction, that they cannot overlook Rule 65 of the Federal Rules of Civil Procedure as it pertains to the bond. That if a judge is going to issue a nationwide injunction, that they must do so with a panel of judges. I think the Chief Justice actually has a lot of tools in his toolbox to do this on his own, what we would also do through legislation.
Just to clarify for most of us who are not lawyers, the importance of the bond issue is, in order to file this claim, you have to put up a large enough bond that if you lose the case, the bond then pays for the legal expenses of the person who you tried to get an injunction against. So if a district court judge issued an injunction in a case that had a bond, but that injunction was then turned around by the Supreme Court and eliminated, then the person who'd filed the claim would actually lose the money to pay for the defendant. Is that correct?
That's correct. That's exactly correct. And the purpose of the bond is to secure the rights that if your injunction is ruled invalid by a higher court, that person is now compensated for having been tied up in court for so long. It is meant as a protectionary measure against somebody who an injunction is levied against. And so these are common sense things I think the Chief Justice could do, but which he's not yet done.
In those kind of circumstances, you'd have a lot fewer of these ideologically driven lawsuits. I think 92% of the nationwide injunctions against Trump came from Democratic judges. From an activist on the left, this is just a free hunting pass. But if they had to actually post a bond, it would suddenly could become a very expensive project.
Correct. And you know how most of these things go. The plaintiffs are plaintiffs, but their entire litigation is funded by some third-party group, right? Which is also why we probably need third-party funding legislation and laws in federal courts to show who's funding these things, who's behind the lawyers who are making the case. So you find a friendly plaintiff, you find a friendly jurisdiction, you put up the money, and you go, like you said, try to get a free shot. And if the judge isn't enforcing Rule 65 as it pertains to the bond, then you really have a free shot. There's nothing that compels you to think about your actions before you take them, that you truly have a friendly judge and a friendly jurisdiction. And more often than not, as the evidence suggests, you're getting these nationwide injunctions where you otherwise couldn't afford to do so, or that legally would be disputable in other jurisdictions around the country.
At the present time, if you're a left-wing activist and you find a friendly judge, you just go in and say, I've been harmed, or that this is unconstitutional. You file it. There's no risk to you at all. You tie up the government in trying to fight over this. The judge issues an injunction blocking the Trump administration from doing the things that it got elected to do. And it's essentially a happy hunting season with no consequence.
Correct. The Constitution is very clear. The courts are there to hear cases and controversies before them, that they're not supposed to supersede some nationwide policy, that if Speaker Gingrich goes before the court is only ruling on Speaker Gingrich's case. They're not ruling on mine and other people's who might be similarly situated. They're ruling on what's right in front of them. And so that's the danger of nationwide injunctions, is that you're by default creating a class action for people who are not even in front of you before the court, where you have not weighed their particular evidence, where you have not heard the government's argument maybe for or against their individual cases. And so that's the risk. The biggest nationwide injunction is the Supreme Court. That's the stopgap, that if cases elevate themselves all the way there, that the Supreme Court can come in and wade in. But you're basically neutering the Supreme Court completely and putting in one district court judge that supersedes the power of the Supreme Court, because they're coming in first. And if you're successful, maybe in an appeal, maybe you might get in front of the Supreme Court, but most cases never make it that far.
Well, a totally different topic for a second. You represent South Carolina. When you go back home, what are folks telling you? Do they think that Trump is moving in the right direction? Or they think that there's real change happening? Or what kind of feedback do you get when you visit back home?
Well, I guess it depends, right? I mean, if you're a liberal, you're absolutely incensed and you're mad. You're furious. But most people that I talk to, people who study politics or history, or maybe just your average guy or lady, they're thrilled with what's going on. They like the shakeup of the Washington establishment. They like that the president is doing what he said that he was going to do. They are thrilled that he is enforcing the laws that we have on the books as it pertains to illegal immigration. They are thrilled that the president is holding other countries accountable for their actions and how they're taking advantage of the United States. They are beyond thrilled on the president's stances as it pertains to taxes and everything that he is doing. So certainly the conservatives are happy. But I would also say that your average American who might watch the news once a week, they're very happy with what is going on. I see them in the airport. I see them in the streets when I do a festival in the district. They're really pleased with what's going on in our nation's capital. Common sense is back. They see it, they feel it, and they're excited about it.
Do you enjoy the process of being a congressman?
I do. I mean, it's frustrating like everybody else. I mean, I'm sure you recognize this. There's immense power in what you do, but you look at that building every day that you work in and you're just in awe that I get to work in this building, that this is the symbol of the free world, that we are a nation of laws, that we are three co-equal branches of government, that a population in South Carolina along the coast and the PD regions of our state elected me to represent and be their voice in the Congress. And so even when I'm frustrated, I think about that mission. I think about the importance of this moment on the country and on the future of the country. And I'm excited about it. I'm optimistic about our future. And I know that we can get the job done.
Does it strike you, this is one of the things I think the public least understands, that you fly into Washington, you go to work, you work 4 or 5 days, you fly home, and you immediately continue going to work. I mean, it's not like you have a weekend off because you go to town hall meetings, you meet with people, you listen to constituents. My experience was that it's a very hard, time-consuming job, and you've got to be really dedicated to doing it. Is that sort of what you experience?
Absolutely. And I kind of joke about this, Speaker, and you'll appreciate this. You know, even as a freshman congressman last Congress, this is my second term, I said, my gosh, I work more than the President of the United States, right? I mean, the President of the United States is in the office 4 hours a day and sleeps presumably 20. And here I am at 16 hours, 17 hours in a day. And then when you're home, you're not sitting around your house. You're out in the community. You're meeting with local leaders. You're talking to job creators in the district. You're trying to understand what's happening, what the federal impact is on the local level so that you can do your job when you're back in Washington. It's incredibly time consuming, but good.
You clearly worked harder than Joe Biden.
Yes, sir.
I'm not quite sure you work harder than Donald Trump.
No, I don't think any of us do.
I think that may be almost impossible.
That's true. That's very true.
Don't you find it's really exciting to be part of this?
I do. I think the mission is great. The weight of the moment is very powerful, that we have a very big job in front of us. We've got to get together and do our work in pass the president's agenda, support the president. And that if we do that, that's not just favorable maybe for the next election, but that's going to set this country up for the next generation. And that's why you served, and that's why I serve today.
I've been very impressed at having been Speaker and having served in the House for 20 years, watching Mike Johnson grow into this job. He was a backbencher, basically. 15 minutes later, he's Speaker. We never had the kind of narrow majority you guys have had. And I think it's been fascinating to watch almost the entire team, not quite 100%, but almost, really begin to be a team, to work together to get things done as a majority rather than in the minority. You can have lots of negatives because you're not going to get anything done anyway. But if you're the majority, you really got to pass stuff. And the size margins you've had, which of course went up by 2 when we picked up those 2 special elections in Florida.
Yes, sir.
Don't you feel that there's a much greater team spirit than there was 6 months ago?
I do. And I think that the Congress has certainly seems to have healed old divisions, that things that plagued us from a division standpoint are not as existent. And I think we all want to drive the president's agenda. We know that despite our differences amongst Republicans, that we are much more alike than the other side of the aisle, and that if we're going to succeed, that we have no other choice but to stick together. That if a bill comes to the floor, it might not be my perfect version or your perfect version, but it is a infinitely superior version than what the other side would propose. And I think people recognize that, both the conservatives and the moderates in the Congress. And you're starting to see very early signs of an esprit de corps, if you will, amongst Republicans, and that we're driving an agenda despite the fact that we have the narrowest majority in the modern era.
Well, I'm very proud of all of you. I think you're doing a remarkable job. And Russell, I want to thank you for joining me today. I want to let our listeners know they can find out more about the work you're doing for South Carolina's 7th Congressional District by visiting your website at fry.house.gov. And I really appreciate you taking this time.
Thank you, Speaker. What a tremendous honor to be with you today. Appreciate your testimony and look forward to seeing you again.
Thank you to my guest, Congressman Russell Fry. You can learn more about his work on the House on our show page at newtsworld.com. Newt's World is produced by Gingrich 360 and iHeartMedia. Our executive producer is Garnsey Sloan. Our researcher is Rachel Peterson. The artwork for the show was created by Steve Penley. Special thanks to the team at Gingrich 360. If you've been enjoying Newt's World, I hope you'll go to Apple Podcast and both rate us with 5 stars and give us a review so others can learn what it's all about. Right now, listeners of Newt's World can sign up for my 3 free weekly columns at gingrich360.com/newsletter. I'm Newt Gingrich. This is Newt's World.